Hello, and welcome to this free presentation for personal representatives, also known as executors or administrators who are handling the probate process of a loved one where the real estate is that needs to be sold. And you may have just petitioned the court to be the executor or the administrator of the estate, or maybe you have already been approved, but either way, if you are still at the phase where you are considering selling the property, this webinar is for you. And before we go any further, I just want to offer my condolences at this time because I know firsthand how stressful and overwhelming this time is, and especially if there's a property to be sold as part of the probate process. Now, my name is Mike Castaigne. I've been a licensed real estate agent for over 20 years, and I'm also a probate and trust specialist where I have received specialized training as it relates to real estate sales during the probate and trust process. I have also learned from and been mentored by and am currently in business with some of the leading experts in probate real estate sales who have over 40 years of knowledge and experience specifically with probate sales. The two gentlemen who are pictured on this slide with me are Gary DeGrazia Sr. and his son Gary Jr. Now, Gary Sr. began focusing on probate sales exclusively back in 1984, and he literally wrote the book on the subject. That blue book, Diamond Farming, that you see in between their two headshots, he wrote that. That's a training manual, and he developed a training program to teach real estate agents like myself and many others how to specialize in this specific area, because probate sales, as we're going to learn through this webinar, are vastly different than regular real estate sales, and that's due to all the legal requirements and associated timelines that are involved. Unfortunately, Gary Sr. passed away a few years ago, but his son, who began working with him exclusively on probates back in 2010, has continued his legacy of not only focusing exclusively on probate real estate sales in his own real estate practice for about the past 20 years, but also he continues to teach other agents across the nation the proper way to conduct these transactions. Now, with that said, it's been both my honor and my benefit to be taught and mentored by both of these gentlemen. And I'm happy to say that today I'm in partnership with Gary Jr. as we both focus exclusively on probate real estate sales in our daily business activities. And for full disclosure, I am not an attorney, nor am I providing any legal advice. I am simply sharing my knowledge as it relates to selling real estate during the probate process, and I defer to your estate attorney on specific legal topics. What I'm sharing with you today will touch on the basics of selling real estate during the probate process. Now, selling a home in probate is vastly different than selling a home in general. And here I'm going to show you those differences. I'll also share with you what to look for in a real estate agent when the time comes to sell the property. After this webinar, you're going to know what questions to ask and what to look for within agent's experience so you can make a real strong choice on that. We're going to cover the different selling options that the estate has. It's not always an option to just list the home on the MLS, as each estate's situation is very unique. And I'll share with you additional services and resources available that may help you through this process. Let's first talk about how to list a home for sale when a home is in probate. First of all, unlike a typical listing agreement, a probate property can only be listed for 90 days. In a typical regular real estate sale, agent would typically list a home for 180 days, about 6 months. But in California law, that can only be a 90-day period. So that's one difference. And also, unlike a typical sale where the seller's name matches what's on the deed of title, with a probate real estate sale, the estate's name would actually show up on the seller's line on the contracts, and it would read something to the effect, and the executor's name would actually have to be on there too. It would read something to the effect, Jane Smith, executor of the John Doe estate, or in the case of an administrator, it would say Jane Smith, administrator of the John Doe estate. Then there's the probate advisory. The probate advisory is a disclosure that must be included. This is a document that details all of the estate exemptions as well as what is required from the estate. Along with the probate advisory is another disclosure document that's called the probate listing addendum, which includes similar clauses in terms of the sale that are found in the probate advisory. All these two previous disclosures I discussed are just to notify the estate of their responsibilities as well as the buyer of the estate's exemptions and some specific terms related to probate transactions. And then in addition to the probate listing, I include my very own special probate addendum. My probate addendum isn't an addendum that most other agents include unless they have received training that I did from Gary Sr. or Gary Jr. And that's because it's not required by the state of California to include. The purpose of my special addendum is to outline protections for the estate from any unforeseen extensions or challenges brought on by the probate that potentially could affect the escrow timeline. Again, most agents are not aware of these special clauses and terms to supplement the purchase contract unless they receive the same training as I did or they're an agent within my network. Here's a snapshot of some disclosures or the disclosures that an estate and probate is exempt from providing when selling a property. The TDS, which stands for the Transfer Disclosure Statement, is a disclosure that the seller is required to mention everything they know about the property, all the material facts about the property. Now, since the owner of the home is now deceased, the executor or the administrator is now acting lawfully on their behalf, but how are they expected to know everything about the property since they didn't own it for that period of time? So you wouldn't be expected to complete this disclosure, and therefore the estate is now exempt from supplying it. The NHD, or the natural hazard disclosure, is typically provided and paid for by the seller, in this case the estate. And in the case of a probate sale, the seller is, or now the estate is, exempt for providing it. And now that responsibility shifts to the buyer, and now the buyer is responsible for purchasing that specific natural hazard disclosure report. And that's at a cost of about $100 or so, more or less. In probate, the estate is also exempt from replacing smoke detectors. However, in probate, the estate is required to replace carbon monoxide detectors. And now it could get a little confusing, I know, but when you're working for me, I make it real easy. Me and my team, we take care of all this for our clients. We always replace all the smoke detectors and all the carbon monoxide detectors, and we replace them with combination smoke / carbon monoxide detectors. We absorb all the expense, and it's done before the property ever has its appraisal. And there's never any issues. So that's just a part of the service that me and my team provide, and take care of all that, so the estate doesn't have to worry about that. Additionally, the estate does not have to provide an earthquake guide to the new buyers. Now, you might have been, before this webinar, you might have been asking yourself, where is all this information found? Because you may have been receiving a lot of phone calls and letters from real estate agents and investors inquiring if you plan on selling the property. Well, the petition for probate, this is the first document that's filed to start the probate process. It's a 4-page document, and page 1 consists of nearly everything that we need or want to know. And this document is public record. It's easily accessible at the county superior courthouse in the records office. And that's why once this document is filed, shortly thereafter, you probably start receiving, as the administrator or the executor, you probably start receiving phone calls and letters from real estate agents and investors asking if you are interested in selling the property, because it's a public record. Now, when it comes to selling assets in probate, this is the document that's most important. The certified letters are what give you the legal authority to convert the assets of this estate to their monetary equivalent, such as selling the house, for example. In the case of real estate, having the certified letters will allow the administrator or the executor to sign a listing agreement, be able to accept a offer for purchase, and then also sign the grant deed during escrow to transfer the property to the new buyer. There's 2 different ways to receive the certified letters. If there's a will associated with the estate, then you're petitioning to be the executor. And once you're approved, you'll receive the certified letters of testamentary. This circumstance indicates that there is a will and the decedent passed away, testate. That term testate is a legal term. When the state is petitioning to be the administrator, when the individual is petitioning to be the administrator of the estate, once approved, you'll receive the letters of administration. And that means that the decedent did not have a will. And this is called intestate. Now, both the letters of administration or the letters of testamentary give the same authority to act on behalf of the decedent to handle the financial and other affairs related to closing the estate. Another important fact to understand is if you're petitioning for full or limited authority. Full authority is most common, but these 2 are very different. Limited authority means that the court approves and oversees everything that you want to do when it comes to sell the property. In a limited authority, the sales price must be at 90% of the appraised value, and the appraised value is not your typical appraisal that's done in a regular real estate sale. The appraised value is conducted by a appointed court referee who's actually a certified public accountant, and they appraise the value based on means by doing a search on the computer of recent sales and doing a drive-by a property. They do not enter the house to appraise it, so the value that they appraise it at may or may not be very accurate. Also, the buyer must have a 10% deposit ready to go. And this 10% deposit to purchase a house, if you think about it, especially in the state of California, can limit your buyer pool because 10% is pretty exorbitant when you're considering a million plus property value. And then also the home will continue to go under court calendar for a court overbid session when it comes time, and the whole process is just overseen through a lot of court hearings, and it extends the time frame of the probate process. As the executor, the administrator, you're going to potentially want more freedoms to do whatever is best that suits the need of this estate. But with limited authority, this situation itself already wipes out a large portion of your active buyer pool. Again, because of the 90% appraisal price and the 10% deposit, FHA loan buyers are immediately eliminated from potentially purchasing the estate home. And more importantly, you and the family have less control over what happens with the property because of the court oversight. Now, full authority, on the other hand, gives you all the control. And again, based on the unique situation of the state, with full authority, you have the freedom to sell for whatever price you agree upon. Any deposit amount is acceptable that you agree upon with the buyer. And there's no court oversight or court overbid process, which allows you and the family to liquidate the asset in a very, very timely fashion. The title company is going to require probate specific documents in order to ensure and close out the sale. And for my clients, I'm not going to hassle you to have to go get an extra copy from the courthouse and send it to the title company. I take care of all that for you, and your attorney doesn't have to worry about it either. That's another part of this service I provide is I take care of all this, and I go to the courthouse, and I just do this for all my clients, and it saves a great deal of time. Now, specifically, the documents that are needed to close escrow, in addition to the certified letters that we talked about previously, is the notice of proposed action is another document, and this is commonly referred to by its acronym NOPA. And this is issued to all heirs and their beneficiaries. Anytime an action is taking place, like the sale of the house or even signing the listing agreement, the NOPA is sent out to all the heirs and the beneficiaries, and it has a 15-day expiration. And during those 15 days, any of the heirs or beneficiaries can either consent or they can object. And if no one consents within the 15 days and those 15 days expire, that's basically the same as giving consent. So after the consent happens, whether they consent by writing or the 15 days lapse without any objections, that action can continue. And in the case of a purchase contract being entered into, the estate can proceed to close escrow. Now, if all the heirs, maybe it's a smaller heirs and beneficiaries, maybe there's only one or two or three heirs, and they all agree that this is an action that they want to happen, they can speed up that 15-day period by providing a waiver to the NOPA. And that would actually speed the process up and be less than that 50-day period, so they can proceed to close escrow on the real estate, for example, and have that money deposited into the estate's bank account ready for final distribution. And then lastly, the third document is the federal tax statement letter, which is also called the comfort letter. And this letter is basically a letter that comes from your estate attorney, or in the case that you're acting on this case pro per, it will come from the executor or the administrator. But this letter basically says that the estate is in good standings with federal taxes. And this is required by the title company. So the title company can close escrow and they can issue title insurance. Now, the probate process, as I said, it starts with the petition for probate. And very quickly thereafter, there's a notice of the first court hearing that's published in the newspaper. And a hearing date is set. And that's hearing date, I put 6 weeks. It can happen sooner than that. It could happen anywhere from 2 weeks to 30 days, up to 6 weeks. I kind of estimated on the long end, but it could happen sooner than that. And during this hearing, there's going to be duties and liabilities that are going to be issued to the administrator or executor. And then this is where we're petitioning the court for those letters of the certified letters that I discussed. After the hearing, within a couple weeks after the hearing, the court is going to approve the administrator or the executor granting full or limited authority, and those letters, those certified letters, will be issued, as well as an order for probate will be issued. And sometimes in certain situations, there may be a bond that the judge deems is necessary, and a bond will need to be issued. And a bond is basically if there's some financial issues that the court feels that need to be addressed or planned for, a bond would be issued just in case the estate cannot handle its financial responsibilities throughout the probate process. Now, after those letters are issued, as I said, the estate under the Independent Administrative of Estates Act, if you have full authority, if you're the executor or the administrator and you were given full authority, this is the time in with real estate that you can actually sign a listing agreement. And actually, we could, while we're waiting for those letters to be issued, if the state wanted to, if the executor wanted to, we can enter into a listing agreement subject to the letters being issued. But at any rate, once the certified letters are issued, the executor or the administrator can sign that a listing agreement and put that property on the MLS or market it however the agent and the estate decides to do that. When and if a purchase agreement becomes available, we can accept the purchase agreement and the probate purchase addendum, as we discussed, and open escrow. From there, as we discussed, a notice of proposed action would be sent out to all the heirs and beneficiaries, alerting them of every action that takes place during this time, such as the listing agreement and the property being placed on the MLS. Another NOPA will be sent out to the heirs and beneficiaries when the administrator, the executor, accepts and enters into contract of purchase, and so forth. From here, this is by also having those certified letters issued, the estate can now open the estate bank account and have a EIN number apply for, and have a EIN number issued to the estate. And this EIN number, if you're not familiar, is basically a entity's social security number. So now the estate can file their last tax return, since the decedent is passed away, and this all these assets are in the estate, are in probate, and will be liquidated. There will be estate taxes that need to be filed and paid for, and we use this estate EIN number for those purposes. And any assets that are sold, the proceeds will be deposited into that estate bank account, and then wait for final distribution at the end of the probate process. Now, again, as in a limited authority situation, still under the Independent Administrations of Estate Act, we already discussed that the selling price must be within the 90% of the probate referee's appraised value, and there must be a 10% customary court deposit based off of that appraised value. And there's a lot of other steps that all these court hearings and offer acceptances must be published in a newspaper, and is just a lot of court oversight and notifying all the beneficiaries and heirs and interested parties to ensure that that the heirs and beneficiaries are aware of all the actions that are going on. And that really extends the probate period tremendously. So basically, if you see where the letters are issued, where the certified letters are issued at that, 6 weeks to 2 month period, after that NOPA under full authority, after that NOPA is after that 15-day NOPA expiration period, the estate can close escrow very, very quickly, within about a few days after that. In most cases, if the funding is available, if it's an all cash deal, it could close within 3 days after that 15-day expiration of the NOPA. Whereas the in a limited authority, that sale is going to take approximately, could take up to 6 months from the start, or at least 4 months from the letters, certified letters being issued by the court. So there's a lot longer time period with limited authority. Also, on the top of the diagram, you're going to see within the first 90 days, there will be some notices that need to be sent out by the state to the franchise tax board and healthcare services to notify them that the decedent had passed away, and if there's any money to be collected, now's the time to initiate those actions. Also, within the first 120 days after the letters have been issued, the executor or the administrator is going to gather the assets and file an inventory and appraisal form. This includes the real estate as well as any other valuable property that the decedent may have owned. A notice to additional creditors is going to be investigated and sent out, and there's going to be a period for the allowance and rejection of creditors' claims, and then again any monies deposited into that estate bank account from liquidating the assets. That's how those creditors and other entities would be paid off. And then after all those things items are achieved, then there will be a petition for final distribution, and this is an accounting process where all that inventory and appraisal, as well as the monies that were deposited into the estate bank account, would be reconciled. And then there will be a court hearing. So whatever is left over would be distributed to the heirs and beneficiaries. Now, in most cases, start to finish, the timeline looks around 6 to 7 months. I kind of, again, overestimated because it can happen depending on this. Every situation is unique. It can last up to 10 months, and sometimes it lasts 12 months. Sometimes it lasts a year or more. But generally speaking, you can proceed to final distribution and close the probate process within about 6 months or maybe a little more. One thing to note, if the heirs or beneficiaries are really in need of money, like with the full authority example, and you find a buyer real soon after the letters are issued, and that money is deposited into the estate bank account, there are services out there that will advance the heirs and beneficiaries inheritance money, and then that company who advanced the money to the heirs and beneficiaries would then recoup their money at the end of the probate period at final distribution. Obviously, there's going to be a cost to that and a service fee, but it is available, and we have those associations with those type of companies. So that's the probate process and timeline. And now let's talk about what to look for when you're hiring a realtor, or even talking to an investor if you're thinking about going that route. Because as I said, real estate sold during the probate process is subject to, as you saw in the previous slide, is subject to many different legal requirements and timelines than a regular real estate transaction. So here's a few questions to ask. What are the certified letters, and why are they important to the sale of probate real estate? Again, the certified letters give the executor or the administrator the legal authority to act on the decedent's behalf for all the financial aspects of closing the liquidating and closing the estate. And it's one of the required documents to close escrow. The second question would be, what is the notice of proposed action, or the NOPA as we refer to it, and why is that important to the sale of probate real estate? As we learned, the NOPA is the document that notifies all the heirs and beneficiaries to the state of the actions that the executor or the administrator is taking, and they have a right to object to that action. And what I didn't mention earlier is if the heirs, any of the heirs or beneficiaries, actually object to the proposed action, like the listing the property for sale or accepting an offer on the property, in the case of real estate, then everything for that particular action then has to have a hearing date scheduled, and it will be brought before a judge to decide whether or not that proposed action can go forward as planned, or if it is disqualified, or if there needs to be a change. So that stops the process if they object. But that's why it's very important, because if there's a stakeholder, heir or beneficiary, has the right to either consent by letting the 15-day period lapse, or, as I said, they could sign a waiver to speed up that 15-day period, or they can object in writing on the form, on the NOPA form they actually received on the back. They could just check the objection box and return it to the court. Another question is, how long is the listing agreement in a probate real estate sale? As we learned, the most traditional way to list a property for sale in a regular real estate transaction is 180 days. But in a probate transaction, the maximum time you could list that property for is 90 days. But if this property didn't sell at the end of the 90 days, we can go ahead and extend that listing agreement for another 90 days. Or the estate can find another real estate agent if they wanted to at the end of that 90 days. Another question is, what disclosures is the estate exempt from? And we talked about the transfer disclosure statement is exempt. The natural hazard disclosure is exempt. The smoke detectors are exempt, but not the carbon monoxide detectors. And again, my team and I, we take care of that for the estate at our cost. And then also the earthquake guide is also exempt in this in a probate sale. And then what is the difference between full and limited authority? Full authority is there's no court oversight. The executor and administrator can do everything unsupervised and does not need court approval for any of the actions. The only approval they need is via the NOPA, as we've discussed in detail. In limited authority, every action there's court oversight. There's a 90% appraisal value that's generated by a appointed court referee who's a certified public accountant, and that could either be, in most cases, it's very non-accurate. There's a 10% deposit required, as well as it really limits your buyer pool a lot, and it really extends the time in which the property can be sold, and it really extends the probate process extremely. If you want more information and some more questions, go ahead and text. I have a special report. You could text 10 questions. You don't need the quotes, but just text 10 questions to 510-369-5080 for that special report. And we'll be able to, and that will be a immediate download. And that has a lot more questions in detail and a lot more thought-provoking things for the estate to consider. Now, in terms of sales options, me and my team, we have about 4 sales options that the estate can consider. Now, there's let's just talk about each one individually, and every estate has its own unique situation. And in this case, we have our easy all cash offer. This might be a situation where maybe the executor or the administrator lives out of the area, either somewhere far away in state or possibly lives out of state and is managing this process remotely. And if there's any errors, they just want to get rid of the property. There could be a lot of deferred maintenance to the property as well, and they don't want to the state does not want to deal with the headaches and the timeline of all the fix-ups and cleanups and so forth. We can generate a easy all cash offer for you. and this would happen. The close of escrow would happen very quickly. And again, those monies would be deposited very quickly into the estate's bank account. In an easy all cash offer, there will be no commissions because me and my team have relationships with our buyer database. And in this situation, we would structure the transaction to where the buyer would end up paying our fees. In this situation, again, the escrow fees would be covered by the buyer. There will be no cleanups involved, no appraisals, no inspections, no repairs. And as I said, a really quick close of escrow pending the NOPA. Again, it would be quicker if we get all the heirs and beneficiaries to sign a waiver. But if it's a regular situation, that NOPA, if there's no objections, when that NOPA expires within 15 days, and it's an all cash offer, we could pretty much close about 3 days after that. And that money can then be transferred into the estate's bank account, ready for final distribution. Another option is an off-market retail sale. This is a situation where it's not going to be listed on the MLS and all the other associated websites. And me and my team would just market this opportunity to a select group of buyers. And this would be a situation similar, but not exact to the previous all cash offer, but you're going to get retail price for this. And this would be, again, we can accept a full retail offer subject to court approval, meaning that we're waiting for either the certified letters to be awarded or the court to approve some part of the probate process. This might be a situation where the estate does not want to go through the hassle. This property is probably in better physical condition than the all cash offer situation, but it might not be HGTV, condition, top of the market condition, where you would really want to put it on the MLS. We would have a reduced sales commission. The buyer would pay the majority of the commission, but in most cases, we would have to have the estate participate a little bit in this commission structure. And then we'd reduce you, the estate and the administrator and the executor, from all the nagging phone calls from agents and investors. You would just kind of tell them, hey, call Mike and his team, and we'll deal with those people and take control of the transaction for you from there. Another option is the on-market retail sale. This is where the estate wants to go ahead and maximize the potential sales price of the property, and have a full listing service and a full marketing plan. Just similar, very similar to a regular sale you would see on Zillow or the MLS or those associated websites. So we're giving full exposure to the market, includes professional photography and some type of either physical or virtual staging. This would include clean out, and we will want to consider improvements to the property, cosmetic, and maybe even some remodeling, depending on what the estate wants to do. This situation, depending on the market, we're going to have to evaluate the current market conditions as well as the competition in the area to ensure that you're going to get top price. So this is something to consider. Again, every estate's situation is different and unique. So this is something that's open for discussion. What we would really have to do is considering all the factors that go into bringing the property to the top of the market and wanting to maximize the sell price, we'd have to really develop a competitive pricing strategy for this type of situation. And then finally, let's say the estate didn't have the money to perform all those repairs, improvements, or remodeling items that they wanted to bring the property to top of the market. We do have a fix-up turnkey program where me and my team will manage the repairs and the rehabilitation of the property with our vendors, and those cost of repairs are billed to escrow with a service fee, but then they're not payable until the property closes escrow. So this is an opportunity to maximize the sales price and receive top dollar for the property. Again, we would really want to scrutinize the market and the current conditions and enter into and really discuss a competitive pricing strategy so we can ensure that the estate is going to have the net proceeds that that would benefit them. So moving on to some additional services that me and my team provide, and I'm not sure what other agents are doing out there, but me and my team provide a complimentary initial trash out of the property if it's required. There is a dollar limit on that, but we can provide a initial trash out and cleanup of the property to make it more appealing when it does hit the market, and to alleviate some stress and work for the estate. Along those lines, we will provide some landscaping to give the property more curb appeal. That initial landscaping service will be performed at our expense. And as I said, we do the smoke detector service, but we have a handyman who can perform some minor and light handyman service, so the property can be in good condition for property inspections and potential buyers when they come and look at the property. Aside from that services that the estate would be responsible for the expenses, we have a full host of affiliated contractors and service providers in all the different trades who could help bring the property to the condition it would need to be if you wanted to put it on the market. And from painting, flooring, plumbing, electric, we even have house cleaners. And if there was an estate sale needed, we have associations with those vendors as well. So when the estate is ready, my team and I are ready, and I service families and estates in Northern and Southern California. I am primarily based out of Northern California. I live in the Bay Area, but I can handle any transaction in the Northern California region, basically from myself from the Central Valley up through the Northern California border. I could handle those myself. Me and my team here locally can do that. And if it's southern of the Central Valley, I have affiliates and associates who, again, have the same training that I received from Gary Sr. and Gary Jr., who I mentioned earlier, and they're part of our probate network that we can team up, and I could manage remotely in conjunction with them being the local expert in the area to service those needs. So please, if you have any questions about this presentation, go ahead and contact me. And I would welcome you to schedule a no obligation like Zoom meeting or a phone conference with myself. And if you wanted me to have Gary Jr. on the Zoom call or the phone at that time, we can make those arrangements. My phone number, you could call me or text me anytime, and I'll get back to you directly. Here's my email. And if you want to schedule that Zoom or phone call, you could just go to my website and there is a scheduling link there. And likewise, you can right now go ahead and scan this QR code, and that will take you to my website. Actually, the QR code will take you to a resource page. There's a quick 2-minute video where you would watch, as well as enter your name and excuse me, your email and phone number. And then I will take you to a resource page, which has many of the resources and more that we discussed during this presentation. And there's also a scheduling link that you can access at that point. So thank you for attending this this webinar. I hope it was helpful. And again, I offer my sincerest condolences to you and your family regarding the loss of the loved one. I know firsthand how challenging, stressful, and overwhelming this process can be. And I just want to let you know that I'm here to help as a resource. No obligation. If you want any information, please don't hesitate to reach out and we could discuss options further. Whether it's me and my team who help you with the disposition of the real estate, or it's another agent, we're here to help. So please utilize any of the contact methods on the screen, and I look forward to speaking with you soon. Thank you, and talk to you soon, hopefully.